general knowledge requirements, which I am sure Your Honours are very familiar with. So, with respect to the question whether the common plan entailed the occurrence of murders as a virtual certainty, the answer is an emphatic and resounding no. First of all, let us recall what the prosecution defines as the former president's list of high-value targets, what the media calls the kill list, and what one of Mr. Edward Jeremy's quoted witnesses referred to as the dead list. The number of individuals on this so-called kill list, the very list on which the prosecution relies to show the knowledge that death would ensue, is 4,817. Those who are actually neutralized dwarfs in comparison and stands at 248. So, assuming that neutralized actually means killed, which it does not, then there is no virtual certainty attributable to Rodrigo Duterte that death would ensue from this kill list. Rather, a 5% chance. Let us have a look at a bar chart for exactly the same figures used by the prosecution as distributed geographically. I now turn to the issue of control, as it did or did not manifest itself in the crime base. In other words, can it safely be argued that substantial grounds exist to believe that Mr. Duterte's supposed diktat filtered its way down from his mouth and via his co-perpetrators to those who were supposedly going about committing these murders? How has the prosecution shown the concept of automatic compliance, or even virtually automatic compliance, so essential to its pyramidal structure? Well, by and large, and judging from Ms. Robin Croft's submissions, it would appear that the concept of automatic compliance is substantiated by reference to subjective comments made by perpetrators who talk about their will being controlled. For example, transcript, page 37, line 7 onwards. I felt like that I didn't have any choice but to follow their orders. It wasn't possible not to obey his commands. Another example. Transcript, page 38, line 17. Co-perpetrators controlled the will of the physical perpetrators. End quote. According to the prosecution, members of the Davao death squad had to seek clearance from Mr. Duterte to conduct killings in Davao City. For this wild assertion, the prosecution relies once again on the evidence of criminals it has recruited, all of whom are inherently unreliable because of their being self-confessed vicious murderers, testifying in return for virtual immunity from proceedings at the ICC. We shall analyze the testimonies emanating from these individuals in detail later in my submissions. Now, I can see Mr. Nichols scribbling away there, but I shall be referring to what are called statements of limited use. As for the other modes of liability charged, ordering under Article 25.3b and Article 25.3c, aiding and abetting, as I have said, no smoking gun, no evidence of a direct order, solicitation, or inducement with respect to any one of the 49 incidents. No documentary record exists of a presidential order. So how could these orders have been transmitted for the purposes of Article 25(3)(b)? Well, unless Mr. Nichols envisages mental telepathy, I think that we can discount ordering. The prosecution has failed to elaborate in its oral submissions what it means truly by soliciting. If it means the ambiguous public speeches, then it is difficult to reconcile the frequent exhortations to self-defense with soliciting, unless, of course, you accept that Mr. Duterte super craftily inserted these exonerating comments into his speeches in order to craft himself a defense when the day of reckoning would come. As the prosecution asserts, speaking with a forked tongue, sometimes speaking his mind, sometimes saying what he wants you, your honours, to hear. Furthermore, generalized statements, months before specific incidents, do not establish causation or instruction. For aiding and abetting, there is no reliable evidence that Mr. Duterte provided practical assistance, encouragement, or moral support that substantially affected the commission of a crime, with knowledge of the perpetrator's intent. And finally, on modes of perpetration, modes of liability, I would beg you not to take heed of Ms. Paulina Masseter's assertion that Rodrigo Duterte failed to prevent or punish. The prosecution has not charged command responsibility under Article 28. And the reasons for that are clear. It is the same reason why it cannot prove ordering. There is no ascertainable chain of command descending from Duterte at the top via the co-perpetrators, so-called co-perpetrators, all the way down to the crime base. As I said, it all breaks down at the level of the co-perpetrators. And I would ask you very respectfully not to exercise your discretion to requalify pursuant to Regulation 55, the regulations of the court. But if you do, and you shouldn't, I respectfully submit, you should order the prosecution to resubmit its document containing the charges and its pre-confirmation brief as amended, and to release Mr. Duterte in the interim. Now, I have finished that section of my submission, and I will now turn to the witnesses themselves, and I will be very careful not to mention anything that I'm not meant to. And I will discuss, first of all, the general reliability. A genuine criminal investigation is meant to be directed at establishing the truth. It is meant to elicit facts in an impartial manner and not to present witnesses with a preconceived idea and to seek confirmation thereof, whether it be by way of leading questions or anything else. By this, I mean that the golden thread linking practically every one of the interviews of the prosecution's so-called insider witnesses, who are, for the most part, ruthless criminals, is the a priori targeting of Rodrigo Duterte. In my submission, no real attempt was made to perform this duty of examining exonerating circumstances, or even to establish the existence of other actors who might be responsible for the high incidence of deaths in the context of the war on drugs. Most prosecutors will collate the evidence and thereafter analyze it and decide whether to prosecute with a view to obtaining a reasonable prospect of conviction, which is indeed the standard supposedly applied since Mr. Karim Khan assumed the role of chief prosecutor. A prosecutor is not meant to choose his target in advance and then find the evidence to support a preconceived desire. Now, I'm not going to engage upon a wholesale forensic analysis of the credibility of each and every witness. I am long enough in the tooth to appreciate that issues of credibility and weight are not normally litigated at confirmation, but are left to trial. This case, however, is unique. And as I have said, the prosecution's star witnesses are self-confessed murderers. And most of their statements were taken by the prosecution's investigators with the assurance of limited use. Namely, that anything self-incriminating would not be used against them in proceedings at the ICC. Although Mr. Nichols will undoubtedly tell you that these agreements of limited use are not to be understood as the grant of immunity from prosecution, for all intents and purposes, they are. And I am prepared to wager that we will not see even one, not one, of these incriminating witnesses in the dock at this court, nor in the dock at any court anywhere in the world, after they have been rehoused and given protection at considerable expense to the state parties funding this court. I do not think that I would be alone either in believing that there is something morally repugnant or even questionable from a public policy standpoint to shield not only one, but a number of murderers from prosecution at the ICC just in an attempt to nail Rodrigo Duterte. Indeed, in many common law jurisdictions, the use of a self-avowed murderer to convict an alleged murderer would normally entail vetting and scrutiny of the highest order. Those words, if I'm not mistaken, come from the Crown Prosecution Service's instruction manual. Public source. In fact, I would suggest that it would normally only be approved, firstly, when it is considered of more value to have a suspected person as a witness than as a possible accused. Secondly, whether obtaining the conviction of an alleged murderer is more important than the release of a self-confessed murderer. And finally, whether it is likely that a conviction could be obtained without the cooperation of the self-confessed murderer, or a number of them. Even after this vetting process, most courts and common law jurisdictions require an evidentiary supplement before relying on the sole testimony of a cooperating criminal witness, or what is otherwise called an accomplice witness. Such an evidentiary supplement in legal parlance is called corroboration, and rules exist governing what may be deemed suitable corroboration. I'm pretty sure that these considerations were never considered by the prosecution, for one very simple reason. At least two of the most prominent accomplice witnesses were offered up to the prosecution on a silver platter, and I cannot say by who in open session. Neither the Rome Statute nor its accompanying texts regulate the way statements of limited use are employed. I would like the pre-trial chamber to consider the way academics and the prosecution itself has qualified the implementation of limited use statements in the past. And I quote from paragraph 49, which is open source, of a chapter on the Office of the Prosecutor in the 2022 edition of the Max Planck Encyclopedia of International Law, written by no less than Judge Betty Hohler of this court. And I quote, "One of the agreements the OTP may enter into during the investigation is an agreement with a person suspected of committing crimes within the jurisdiction of the court, is to provide a statement of limited use. The idea is that the person provides the Office of the Prosecutor with an oral or written statement for the purpose of pursuing leads or developing additional information or evidence on the condition that the statement will not be used against the interviewed person except as stipulated in the agreement. The purpose of such agreements is to ensure cooperation of so-called insider witnesses whom the OTP does not intend to prosecute, but are expected to provide key information or evidence against other, usually more senior suspects." Judge Hohler was effectively relying on footnote 20 to the prosecution's own filing, number 1118, in the Bemba Article 70 case, which states the same thing. Both sources stressed that limited use statements should be used as a rule to pursue leads or to develop information, but not apparently, outright at any rate, to serve as the key and main testimony against a suspect. In my opinion, there is a good reason for this, and it is contained in the wording of Article 54, 3d of the Rome Statute, which is cited as the statutory basis for limited use statements. The prosecutor is entitled to enter into such agreements granting limited use on condition that the agreement would not be inconsistent with the statute. And I stress those words, not inconsistent with the statute. Using the evidence of self-confessed murderers to obtain leads or develop evidence from other sources, I would suggest, is consistent with the statute, as mentioned by Judge Betty Hohler. To give a get-out-of-jail card, however, to a whole bunch of murderers in order to fix liability to another, albeit pre-selected individual, also selected of murder, is, in my opinion, totally and wholly inconsistent with the object and purpose of the Rome Statute, which, according to its preamble, oft cited by the victims and the prosecution, is dedicated to the eradication of impunity. In my opinion, granting immunity to a murder suspect for core international crimes would be seen as undermining the object and purpose of the Rome Statute. Accordingly, I would ask the Chamber to find the statements of those witnesses afforded such limited use and to be of negligible evidentiary weight. Another issue pertaining to the general credibility of the prosecution's witnesses is the way in which they were recruited. In my opening remarks a couple of days ago, I talked about the general fairness of pursuing charges brought by a prosecutor who was formerly a representative for more than 100 victims of Mr. Duterte's alleged crimes. I also talked about a recorded telephone conversation in which one of the participants bragged about acting as President Marcos Jr.'s silent partner for channeling witnesses to the ICC. Apparently, I raised the presidential spokesperson's hackles considerably. So let me quote a bit more so that I can assure her that my cognitive faculties, which she doubted, are in fact intact. And this is what this covertly recorded individual, who I am forbidden from naming, said. They cooperate through me, since I don't hold a position. Redacted. But we are able to do it. So what? What happened here is an ICC investigator will give me a list of witnesses, documents they need to bolster the case against Duterte. Then I provide it. I give it to the different agencies so it can be approved. There are witnesses who need a pardon. I get the authority from the president, and they are granted a pardon. Basically, like that, it becomes a priority mission of the government. I don't think I've disclosed here, Madam President, any working methodology of the Office of the Prosecutor. So now I turn to the incidents themselves, the 49 incidents. The prosecution invites you to view these incidents as the manifestation of a much larger pattern. To quote the prosecution's very words in filing number 330 at paragraph 5, the 49 incidents are a non-exhaustive list of examples of the conduct underlying the charges. Indeed, the prosecution speaks of thousands of victims in toto, data sets, and patterns of violence. Now, the defense does not deny that much drug-related violence did occur. It was occurring before Mr. Duterte assumed the reins of power and continued, as we have shown, by way of a sharp increase after he left office. But these grandiose visions of the prosecution are of no avail if the core criminality and incidents alleged in its document containing the charges are not made out. So the question before you is whether there are substantial grounds to believe, firstly, that each of these specific incidents were unlawful killings, namely, deliberate acts of murder, and secondly, that they were knowingly committed to further the criminal objective of the so-called common plan or the state organizational policy with which it has been conflated, and finally, that they are indeed attributable to Mr. Duterte under a recognized mode of liability. Preempting a possible defense, always a good tactic for a prosecutor, unsure of the strength of his own case, there is a heavy reliance on expert analysis of data sets to argue that reported instances of self-defense were statistically improbable. Let me stress that it is the defense's view that if the contextual case depends on the scale of victims, namely thousands, as alleged by the prosecution, then establishing the evidentiary integrity of each charged incident is imperative. In other words, the defence firmly submits that the pre-trial chamber should not commit any one of the 49 incidents to trial unless it concludes that there are substantial grounds to believe that Mr. Duterte's criminal linkage and liability has been established for each one. When these 49 incidents are disaggregated and examined one by one, as the statute requires, we submit, what becomes apparent is not the cumulative strength, rather the recurrence of certain symptoms of inherent weakness in the evidence. These weaknesses fall into 6 broad categories. The first is the over-heavy reliance on the testimony of cooperating witnesses who are inherent criminals with an inherent propensity to be unreliable and whose statements, as I mentioned, are not corroborated by external evidence. The second, hearsay attribution, or in less legal parlance, incriminating statements heard from a source twice or even 3 times removed. The third weakness, which infects the evidence, is the fact that some of the victims are unidentified, making it virtually impossible for the defence to pursue its own lines of inquiry. This weakness affects at least 9 out of the 49 incidents. The fourth weakness, documentary records, such as police and forensic reports, are at variance with and are contradicted by testimony of a single prosecution witness. Fifth, the hoary old chestnut of conflicting statements emanating from 2 or more witnesses testifying to the same event, some contradicting one another, some contradicting even themselves. And finally, the 6th weakness being the repeated absence of any evidence to link the hitmen to our client, despite the prosecution's best efforts to chivvy such linkage out of them. The defence will now show how these identified weaknesses reduce below the substantial grounds threshold the evidence for these incidents in the 3 counts as they appear in the document containing the charges. Count 1, the alleged murders during the mayoral period. Count 2, alleged murders of HVTs, the high-value targets, during the presidential period. And count 3, barangay clearance operations also during the presidential period. So I shall start with count 1. As we know, the first cluster of incidents falling under count 1 concerns the so-called and totally fictitious Davao death squad period. This concerns incidents 1 through 9 of the document containing the charges. The prosecution's attribution theory here is straightforward, that Rodrigo Duterte, as mayor, authorized killings through intermediaries. But when the evidence for this count is examined, as I've already mentioned, not one witness can say that he heard the mayor give an order to kill. The attribution of criminality to Mr. Duterte arises, for the most part, out of assumption layered on top of hearsay and follows a repetitive pattern which would, as a rule, entail the same mechanism of attribution. Namely, a hitman witness for the prosecution would state that his handler said that clearance came from, and I quote, above. But what does the word above mean? It means an unnamed superior and nothing more. The mode of liability imputed to Mr. Duterte, namely indirect perpetration, requires the prosecution to establish a stable chain of command through which the common enterprise filtered. If there indeed existed a structured approval process, as the prosecution alleges, one would expect operational consistency, not variability. The incidents contained in Count 1 are also marked by internal inconsistencies which cannot be reconciled and which are indicative of the fragility of the prosecution's overall case. Incident number 1, for example, is based on the evidence of two witnesses who contradict each other on fundamental and materially crucial issues. Let me explain in more detail. P26, who presents himself as a participant, claims that Mr. Duterte telephoned a redacted third party to order the operation and was told that it was the mayor on the phone. Was told that the mayor was on the phone. Pure hearsay. The prosecution seeks to reinforce this through P2. Yet P2 was not present at the time. He was inactive, for reasons I can't mention, and relies entirely on what he heard from the redacted third party and another individual at a later date. P2's account is therefore pure, unadulterated hearsay. More significantly, it diverges from P26's version on fundamental points. The year of the incident, 2014 and not 2013. The number of victims, 2 rather than 3. The identity of the perpetrators. The channel through which alleged clearance was conveyed, via driver and bodyguard, to a different DDS member rather than through redacted. And if that is not enough, the method of killing, strangulation rather than stabbing, these aren't minor inconsistencies. They concern the core factual matrix. If the pre-trial chamber is unable to determine even these basic circumstances which establish opportunity, method,
mga kabombo, mga ka-Star Nation, nandun na ho tayo sa highlights nitong pinupunto ng panig ng depensa. At siguro kung napakinggan natin yung pagdinig ng Senado tungkol dyan sa usapin ng Davao Death Squad before, familiar ho tayo dun sa nagiging takbo ng statement ngayon ni Nicholas Kaufman. At ito yung mga initially ay nagpakilala na naging bahagi ng original Davao Death Squad umano na naging subject din ng investigasyon dyan sa Senado, mga kabombo at mga ka-Star Nation. Yan yung hinihimay ngayon ng Depensa Lead Counsel na si Nicholas Kaufman, mga kabombo at mga ka-Star Nation. So ginigiba ngayon ng panig ng depensa yung testimonya ng mga hawak na testigo ng panig ho ng prosekusyon. Dito ay kung mapapansin ho ninyo, ina-argue nitong si Kaufman yung tungkol dun sa inconsistencies, yung number ng nasawi at tungkol dun sa nakasulat na testimonya at yung mismong pagtatanong na ginawa dun ho sa mga personalidad ho na yan. So iyan yung mga vital na hinihimay at naniniwala ang panig ng depensa na malakas yung kanilang laban because of those statements na hawak ko nila mula dun sa naging pagtatanong dyan sa mga testigo na bahagi pa rin nitong kaso laban kay former President Rodrigo Duterte, mga kabombo at mga ka-Star Nation. So ito na ho yung pinakang dulo ng mga paghimay dyan sa International Criminal Court at atin hong inaantabayanan yung pagpapatuloy nito sapagkat napaka-interesting na parte kung ano yung mga kumbaga mga atake ng panig ho ng depensa para pabulaanan yung mga initial statements galing naman sa panig ho ng prosecution. Lalo na yung mga inilagay ho nila na tatayong testigo para ho dito sa kaso na ito ng crimes against humanity charges against the former President Rodrigo Roa Duterte, mga kabombo at mga ka-Star Nation. At yan yung diskarte ngayon ng panig ho ng depensa sa katauhan ni Nicholas Kaufman. Ating ituloy mga kabombo ang pag-usad nitong confirmation of charges hearing.
A weak basis since the prosecution.
I-check natin mga kabombo, mga ka-Startation yung linya dyan sa International Criminal Court para sa mas malinaw ho na mga update pa kaugnay nitong presentation ng panig ho ng depensa. So, inaasahan bukas ay matatalakay naman ho yung tungkol sa issue ng detention ni former President Rodrigo Duterte. Ating ituloy ngayon mga kabombo.
The prosecution fixated on the comments of Mr. Duterte telling the person operating the video not to zoom in.
Oras natin, 18 minuto na, makalipas ho ang ika-10 ng gabi at tayo na sa pagtutok pa rin sa mga update dyan sa International Criminal Court, mga kabombo at mga ka-Star Nation. At para dun sa mga late tuners ho natin, mga kabombo, ito ho ang confirmation of charges hearing ng International Criminal Court at ang nakasala ngayon ay ang panig ng depensa o yung kampo ni former President Rodrigo Duterte na kasalukuyan hong nagbibigay ng kanilang mga argumento ang lead counsel na si Nicholas Kaufman at yan ay tungkol doon sa mga argumento na nakatukoy doon ho sa mga personalities na kinuha bilang testigo ng panig ng prosekusyon na ngayon ay kini-question naman ang panig ho ng depensa ang kumbaga consistencies in terms of yung kanilang mga testimonies at iba pang mga detalye na hawak, yung figure mismo, sabi nga niyan normal na may mga pagkaka hindi direktang eksakto na bilang pero napaka-sensitive ho ng usapin pagka ito'y criminal in nature, criminal charges ang ipinupukol dahil merong mapaparusahan the moment na kinatigan ang isang testimonya batay ho doon sa kanilang mga accounts na kanilang inilahad bilang ebidensya. So yan yung pinakang magiging impact ho niyan ay meron hong mapapanagot kung kakatigan itong kanilang mga testimonya. Kaya todo ho ang effort para questionin yung kredibilidad ng natura mga testigo dyan sa usapin ng crimes against humanity na kasong ipinupukol against the former President Rodrigo Roa Duterte, mga kabombo at mga ka-Star Nation. So, ilala pa lamang ho yan mga kabombo, pati ho yung, kasi di ba may mga pagkakataon nabanggit na may mga naisalang na for interview. Ito ho yun mga kabombo at mga ka-Star Nation. No? And marami pa na mga personalities yung naisalang for interview at yan yung magiging bahagi ng mga ebidensya ng panig ho ng prosekusyon. At hindi lang ho matukoy ng direkta kung yung lahat ng na-interview ay kabilang ho sa ipipresent nila na mga testimonya na vital para ho dun sa kaso o sa akusasyon Ngunit mahalaga po ang lahat ng ito upang kunin yung mga kumbaga direktang tutukoy may associate dito kay former President Rodrigo Duterte upang mapatibay yung kanilang argumento at kaso laban sa former president. Yun nga lang, siyempre may mga paraan din ang panig ho ng depensa at may pagkakataon din ho sila para gawin ang pagkwestiyon dito sa mga argumento na ito at mga personalidad na tinutukoy. Siyempre, yung kredibilidad, importante ho ito sapagkat kung sa isang tanong pa lang ay hindi na ho magtutugma doon sa previous statement, ay mabubutasan na yung testimonya ng isa sa mga testigo. Pero syempre, ang mga huwes na nakatuon ho ang atensyon dito ay may mga tinatawag naman ho sila na kumbaga ipataan hangganan kung ano yung pwedeng i-consider at hindi dito ho sa usapin po na ito. At napakasensitibo. Crimes against humanity ang ipinupukol ho against the former President Rodrigo Roa Duterte. Oras na ho natin 22 minuto makalipas ang 10:00 ng gabi at nasa huling bahagi na ho ng confirmation of charges hearing dito pa rin sa tinutugay-gaya natin na usapin sa International Criminal Court mga kabombo at mga ka-Star Nation. And of course, ang panig ho ng depensa ay full force din ho dyan. Pero yung mga iba pang abogado na nagmula ho sa Pilipinas ay hindi naman ho sila nagsalita ngayon dyan sa panig ng depensa. Pero ang kumbaga naglahad ng lahat ng mga argumento itong si lead counsel Nicholas Kaufman mula po sa panig ng depensa o sa kampo ni former President Rodrigo Roa Duterte, mga kabombo at mga ka-Star Nation. Ganyan ho yung kanilang presentation. And of course, yan yung napagkasunduan ng panig ho ng depensa at naniniwala sila sa kapasidad. In fact, doon pa lang sa unang araw, nung araw ho ng Lunes, ay todo papuri yung mga abogado na nanggaling pa rito sa Pilipinas ukol sa takbo ng mga pahayag nitong si Nicholas Kaufman doon sa presentation o doon sa opening remarks ng kanyang mga argumento. At susog din naman dito yung kanyang paghimay ngayon doon sa kanilang testimonya at mga argumento para sa dating presidente ng Pilipinas, mga kabombo. At inhuyang babalikan maya-maya lamang at may kaugnayan pa rin sa kabuuan itong binabantayan natin. Kung ano yung magiging schedule din bukas, atin huyang aalamin sapagkat yan naman ay anunsyo ng mga opisyal ng International Criminal Court bago pa man ang paglalagom ng araw ho na ito para sa ikatlong araw ng confirmation of charges hearing dyan sa International Criminal Court. And of course, alamin din ho natin kung ano yung magiging pasya para dun sa usapin ng detention. Lalo't nag-wave din ho ang former President Rodrigo Duterte ng kanyang pagdalo na dyan sa huling araw. Sa Biyernes ho yan, bukas, at hindi na ho siya haharap ng personal. Although, may pagkakataon sana ang dating presidente na humarap ho dyan. Ay, bukod ho ito mga kabombo, bukod dun sa mga inisyal na bahagi ng confirmation of charges, meron naman yung tungkol doon ho sa detention issue ng former president dahil nga ang kanilang argumento ay hindi angkop, hindi tama yung pagkuha kay former President Duterte at dinala doon sa The Hague noong 11th of March 2025. At mag-iisang taon na ho yun, mga kabombo, mga ka-Star Nation. At yan yung isa sa mga bagay na kanilang kinukontra yung naging proseso ho ng pag-aresto at pagdadala kay former President Duterte dyan sa The Hague. Dahil ayon sa kampo ng dating Pangulo, ito ay extraordinary rendition, ito ay kidnapping ayon ho sa kanila. Although, syempre, ang panig ho ng prosekusyon ay hindi sumususog doon sa naturang mga pahayag dahil meron umanong warrant of arrest na kailangang tuparin, sundin, kaya ho dinala ang dating presidente dyan sa The Hague mula dito sa Pilipinas. Although that time ay hindi na bahagi ng International Criminal Court Rome Statute ang Pilipinas dahil kumalas na ho ito at naging epektibo noong 2019, pero ang sinasabi naman ng ilang mga legal luminaries ay kahit papaano ay may jurisdiction ang International Criminal Court dahil ang pinag-uusapan yung mga kaso na nangyayari bago pa man maging epektibo ho yung pagkalas ng Pilipinas dyan sa Rome Statute, mga kabombo at mga ka-Star Nation. So napakasalimuot ho. Even yung mga lawyers na nakakausap po natin, mga kabombo, ay talagang nagbabanggaan yung kanilang ideya sa mga bagay ho na ito. Lalo na pagka ang kinausap po syempre mula sa panig ng depensa ay iba yung hagkis ng kanilang mga salita hinggil ho dyan sa mga argumento na yan. And of course, yung kabilang panig naman o yung panig ng prosekusyon ay nagdidiin naman dito kay former President Rodrigo Roa Duterte. Check natin muli, mga kabombo, mga ka-Star Nation, yung linya dyan sa International Criminal Court sapagkat importante ho na makuha natin yung huling yugto bago pa man ang paglalagom ng ikatlong araw ng confirmation of charges hearing dyan sa International Criminal Court. And kanina, mga kabombo, konting balik lamang ng mga impormasyon. Kanina kasing araw ay nag-file ng information ang isang grupo. Ito ay yung mga sinasabing dating tauhan ng Philippine Marines. Ito naman ho ay may kinalaman doon sa aligasyon ng suhol doon sa mga investigators ng criminal o ng International Criminal Court na kinakaladkad rin yung mga pangalan ng ilang mga local politicians doon ho sa naturang usapin. Pero mariin naman ho itong itinatanggi ng mga personalidad na napangalanan. In fact, kanina, naisalang na ho natin sa interview yung ilan ho sa kanila, kabilang na itong si former Senator Antonio Trillanes IV at kaninang umaga si former ACT Teachers Party List Representative Franz Castro, no? Nabanggitin ho kasi yung kanyang pangalan. Ganun din yung kinatawan mula sa ikatlong distrito ng Maynila na si Representative Joel Chua, nagpaliwanag na rin ho at pinabulaanan yung pagkakabanggit ng kanyang pangalan o yung partisipasyon dun sa naturang kontrobersiya, mga kabombo at mga ka-Star Nation. Kuha muna tayo ng ilan pang update mula sa ating research team. Si Bombo Genesis Aracho nakatutok din dito ho sa ating special coverage. Bombo Genesis, please come in.
Yes, Bombo Dennis, mga kabombo ka-Star Nation, balikan natin yung kasalukuyang nangyayari pa rin doon sa may International Criminal Court, doon sa may The Hague sa Netherlands. Kasi kasalukuyan yung panayam din kay Attorney Nery Colmenares, nung ating mga Bombo International News correspondent doon. At nababanggit ni Attorney Nery Colmenares ang nagsisilbing legal counsel for families of drug war victims na nabigo itong si Attorney Nicholas Kaufman na makapagpakita ng matibay na ebidensya na makakapagpatanggal o makakapagpaalis dun sa pagkakasala, quote-unquote, nitong si dating Pangulong Rodrigo Duterte sa kanyang responsibilidad sa ikinasang madugo na drug war nung kanyang administrasyon. Kasama na yung malawakang patayan din noong siya ay alkalde pa lamang ng Davao City. Tinukoy ni Attorney Nery Colmenares, Bombo Dennis, yung ilan sa mga memorandum na inilabas nitong si dating Pangulong Duterte, kasama na yung mga memorandum at mga dokumentong inilabas noon nitong si dating Director General Ronald Bato de la Rosa na ngayon ay Senador ng Pilipinas. Tinukoy niya ito bilang kulang at unsubstantial, quote-unquote, Bombo Dennis. So ang sabi ni Attorney Nery Colmenares, yung mga presentasyon na ito ni Attorney Nicholas Kaufman ay hindi sapat na ebidensya, hindi matibay na ebidensya para tanggalin yung pagkakasala ni dating Pangulong Rodrigo Duterte at yung connection nitong si dating Pangulong Duterte at nitong si General de la Rosa doon sa malawakang patayan na nagawa raw ng prosecution na i-establish nitong dalawang nauna na confirmation of charges hearing, Bombo Dennis. So ito yung punah nitong si Attorney Nery Colmenares kasabay nung una at ikalawang session ngayong araw, third day ng confirmation of charges hearing nitong si dating Pangulong Rodrigo Roa Duterte. Maliban kay Attorney Nery Colmenares, ay meron din ilan pang mga international criminal o international law expert na nagbabahagi ng kanilang opinion. Okay, balikan natin Bumbutenis, yung kaganapan pa rin doon sa International Criminal Court kasabay ng ikatlong araw ng hearing.
To interrupt, Your Honors, just at the end of the day, but I wonder if we could go into private session for 1 minute before you leave the bench.
Oui, Mr. Nichols.
Yes, Mr. Nichols.
Mga kabombo at mga ka-Star Nation, yan yung may pinag-uusapan kasi sila doon tungkol ho doon sa bibigay na may argumento itong panig ho ng depensa. May sinasabi pa ito si Nicholas Kaufman at may pahayag din naman yung presiding judge Yulia, mga kabombo, mga ka-Star Nation. So, antabayanan ho natin kung ano yung konteksto nung kanyang binabanggit tungkol doon sa huling bahagi na ho ito, para sa closing, batid ho natin kung ano expect natin bukas para naman sa continuation nitong confirmation of charges hearing, and yan ay may kinalaman. In fact, yung mga proseso kasi, mga kabombo, ay talagang hinihimay din, even yung kung sino yung magsasalita, kung anong argumento yung hangganan, at kung nasusunod yung mga proseso, sapagkat kanina kung mapapansin ng ating mga kabombo at mga ka-Star Nation, yung nagsasalita si Nicholas Kaufman, nagsasite ng mga backgrounder at ganun din nung mga ina-argue niya na mga testimonya galing doon sa prosekusyon, ay pinigilan ho siya ng presiding judge at sinabi na tutukuyin mo every time na magsasalita ka tungkol sa isang partikular na bagay o pahayag, ay dapat tukuyin kung asang reference ho ito para mababalikan at may kukumpare notes kang ito yung sinasabi ni Kaufman, ito naman yung nasa record. So mapagtutugma ho nila at makakatulong sa kanila para magpasya ng patas hinggil ho dito sa kasong ito against the former President Rodrigo Roa Duterte. And upon hearing that, ay nag-comply itong si Kaufman doon ho sa sinasabi ng presiding judge na si Yulia Motok, mga kabombo at mga ka-Star Nation, sa Pre-Trial Chamber 1, at yan ay bahagi pa rin ng International Criminal Court. So mga kabombo, tayo ay nasa huling yugto nito at antabayanan ho natin ang paglalagom bago ho tayo magwakas dito sa ating special coverage ngayong araw ho ng Huwebes. And then tomorrow, ganung oras pa rin ho mga kabombo ang ating pagtutok dito, alas 5 ng hapon. And dire-diretso ho yung ating pag-antabay, although may mga putol ho para naman makapag-unload ng commercials. But of course, habang kayo ho ay nakaantabay, pwede ho kayong mag-check din sa amin pong official website, www.bomboradio.com, sa amin pong iba pang mga social media accounts ng Bombo Radio Philippines habang naka-break ito hong confirmation of charges hearing, and then balik ho tayo sa pagtutok after that dahil maganda na updated din ho tayo dito sa mga kaganapan sa International Criminal Court. Nakakaantabay ho tayo dun sa magiging statement pa nitong si Kaufman at ng mismong mga huwes na humahawak po ng kaso o nakikinig dun sa kanilang mga argumento. At sila din kasi yung magpapasya hinggil ho dito, mga kabombo. But take note, mga kabombo, ang pagpapasyahan pa lamang ho dito ay hindi pa yung pinakang kabuuan ng merito. Ito ay pagpapasyahan kung uusad sa full trial o hindi. Yan pa lamang muna ang initial ho na pagdidesisyonan bago pa man itong paglalahad ng bawat ebidensya, bawat argumento, mga testimonya, mga dokumento at maraming iba pa, mga kabombo. Saka pa lamang ho ito dadako dyan. At usually sabi nga nila doon sa mga nakausap po natin ng mga accredited lawyers ng International Criminal Court, usually tumatagal ho ito ng mga taon. Hindi lang taon, isang taon, kundi mga taon. Kagaya ho ng mga nakalipas na kaso ng mga leader din ng ibang mga bansa na nasalang dyan sa International Criminal Court. But this is the first time na meron hong former Filipino leader na naakusahan ng ganito kabigat ho na reklamo, crimes against humanity, at first time din na nagkaroon ng Filipino leader na ipiit ho dyan sa International Criminal Court. Atin hong balikan dyan sa The Hague.
And now, I would like to wish you a pleasant afternoon. We will see you all tomorrow. And once again, I thank everyone. And this hearing is now adjourned. We will see one another tomorrow.
Ayan, mga kabombo. So, ito na rin yung katapusan ho ng pag-present ng panig ng depensa doon sa kanilang mga argumento. At yun na, nagkumpas na ho ang presiding judge dyan sa chamber, si Judge Yulia Motok, mga kabombo at mga Kastar Nation. So, antabay ho tayo. Bukas muli magkakarinigan ho tayo ng mga update pa mula dyan sa International Criminal Court at kaugnay ng confirmation of charges hearing and yung pagtutok din dun ho sa issue ng detention ni former President Rodrigo Roa Duterte. Yan po ang ating naging pagsubaybay. Katuwang natin ang mga reports at mga panayam din natin hong nakalap sa araw na ito ng Huwebes, mga kabombo at mga Kastar Nation. At Luzon, Visayas at Mindanao, yan ang kalipunan ng atin hong mga balita at impormasyon para pa rin sa Bombo Radio Philippines. Sa mga tumutok sa pamamagitan ng Bombo Mobile App, YouTube, TikTok at maging sa Facebook Live. Maraming salamat. At mula rito sa Bombo News Center, Makati, this is Bombo Radio Philippines, the number one and most trusted source of news and information. Basta Radio, Bombo!
For the most trusted source of news and information, visit our website at www.bomboradio.com. Follow us on Bombo Radio mobile app, Facebook, YouTube, TikTok, and X, formerly Twitter. Like, share, and stay